Hi, I'm Janice Switlo, and on December 3, 2020, federal government introduced Bill C-15, an act respecting the United Nations Declaration on the Rights of Indigenous Peoples, the first reading. Now I'm going to cover a few items from that bill and point out the implications of how they've structured things. But before I do so, first, I'd like to remind you that in Season 4, episode number 28, titled Beware, UNDRIP, May 23, 2020, I released an episode that describes some background on the declaration and why it's a dangerous matter. So I also today, December 10, made a post on my Facebook page, and I'm going to start by reading that before getting into some specifics from quotes from the bill itself. So it's all about removing choice. The member UN state decides. Excellence is never an accident. It is always the result of high intention, sincere effort, and intelligent execution. It represents the wise choice of many alternatives. Choice, not chance, determines your destiny. And that's a quote that I've taken from Aristotle. My efforts always go to preserving the right of choice for Indigenous nationals. Spend your efforts in protecting your nations, not wasting time and money trying to lobby against Bill C-15, the House of Commons of Canada, Act representing the United Nations Declaration on the Rights of Indigenous Peoples, first reading December 3, 2020. Expect it to pass. The Canadian Section 35 Constitution Act 1982, which was the pilot project, is the template for the UNDRIP template to be used by other member UN states to attempt to create new replacement international law for the doctrine of discovery, which is Indigenous nationals are a subclass of human only, never developed or progressed enough to form societies, law, and governance. Get enough member UN states using a similar Section 35 domestic doctrine for long enough period of time will achieve this, unless Indigenous nations decide. Individuals advocated for this and have given member UN states what they need to check the consulted box, which is a key component of the new regime based on the Canadian Section 35 domestic doctrine. But they carried no authorities or powers to decide for the nations and all Indigenous nationals. These self-selected individuals could only speak for themselves. So too with all those individuals who signed the petition to tell Canada to sign on to UNDRIP. Another strategy to bump up the consultation file, given my very public comments that it is not binding on the nations. Those lawyers, professors, chiefs, Canadian corporations, AFN, etc., none could decide for the Indigenous nations, who are still here with their laws and treaties that bind the Crown and all those beneath the Crown, especially her governments in Canada. I know what needs to be done at home to protect against this, and trust me, it is going to get much worse very fast now. What you must do now and put in place so that your next generations will continue to have what you still have. Don't react to and follow an agenda set by and decided by others. Focus on what you control, what you can decide to do. Don't let others decide for you. It doesn't take much effort from you, a gathering of some information and documents, but decide. Decide to start acting as nations. The effort has already been made. I've been at this for decades now to know what to do and how. Or the decision will be made for you and determine your destiny. A mere domestic ethnic minority, no nations, no treaties, no choice. Contact me, let's do this. You're out of time. Don't keep taking chances. Don't allow yourselves to become legal wards of Canada. Inaction is a form of choice too. Don't give up. There is no need. Ancestors provided for you. It's your turn to provide, to protect, under your laws. I respectfully remind you are obliged to do this. Beware the consequences of abandoning your right of choice. So turning then to some specifics from Bill C-15, from the preambles. Whereas First Nations, Inuit, and the Métis Nation have throughout history and to this day lived in the lands that are now in Canada with their distinct identities, cultures, and ways of life. The correct view: Canada is in your lands. Canada is in the lands of the Indigenous nations. Only where there have been final land claim settlement agreements entered into have those lands come and become part of and in Canada. So what the federal government here is trying to do is to put on the record and add to its body of evidence to say, well, it's always all ours. That's incorrect. It's very clear from the treaties that an interest beneath the continuing ownership by the Indigenous nations is what has been created, allowing for an interest for the Crown beneath the ownership of the nations. There's nothing there that says the Indigenous nations and their lands came into and under and part of and beneath Canada. That's a lie. It is, however, how Canadian government wants this to proceed. They cannot, by making a statement like that, achieve such result unless you actually believe it, stay silent, do nothing, fail to act as nations. Then this is exactly what will speak for you. Doesn't have to be that way. Another preamble. Whereas the Government of Canada is committed to exploring, in consultation and cooperation with Indigenous peoples, measures related to monitoring, oversight, recourse or remedy, or other accountability measures that will contribute to the achievement of those objectives. And those are the objectives as contained in the Declaration. In consultation and cooperation. Section 35, key component of the doctrine that allows, under Canadian domestic law, the pushing aside of the people, the Indigenous nationals, is to say, well, as long as we tell you about it first, we consult with you. So clearly, as I have warned, UNDRIP is simply an extension of the Section 35 doctrine, and key and part and parcel of that is this concept that, no, you're not owners, you don't have a choice, you don't decide, but we'll consult you. We will tell you basically what we intend to do. Another preamble, whereas the Declaration is affirmed as a source for the interpretation of Canadian law. So we're talking about Canadian domestic law and how those laws are being interpreted. This is not about putting the Declaration and establishing it as law. It is not going to become part of Canadian law. It will be used to help interpret, should the courts require such help, interpreting Canadian domestic law. Another final preamble I'll bring to your attention, there are more. Whereas the protection of Aboriginal and treaty rights, recognized and affirmed by Section 35 of the Constitution Act 1982, is an underlying principle and value of the Constitution of Canada. So what they're saying is, we're being clear that Canadian law is going to follow the Section 35 doctrine as constituting part of the Constitution of Canada. And as such, the Declaration will simply be used as a source, as it stated, to interpret laws, but bringing it all clearly under the Section 35 framework, which, you know, it's not to be unexpected. The Section 35 doctrine, the framework, formed the basis for the Declaration, and now it's coming full circle. The Declaration is going to be used to interpret the very domestic doctrine that it's founded on. Now turning to the text of the bill. Under definitions, Indigenous peoples has the meaning assigned by the definition Aboriginal peoples of Canada in subsection 35(2) of the Constitution Act 1982. That possessory, again, Aboriginal peoples of Canada. This is very clearly why I use Indigenous nationals of Indigenous nations. It is a completely different concept. So that, again, they're being clear, we're talking about a domestically defined entity, so that Indigenous peoples, which is part of the title of the Declaration, Canada is saying, well, it's defined as we define domestically Aboriginal peoples. Rights of Indigenous peoples. This act is to be construed as upholding the rights of Indigenous peoples recognized and affirmed by Section 35 of the Constitution Act 1982, and not as abrogating or derogating from them. Again, just confirming that the only thing being reinforced here and aligning the Declaration with the Section 35 doctrine, and again, to repeat myself, the Section 35 doctrine is the foundation of the template that the Declaration serves to put similar concepts in place elsewhere in other member UN states. Because if you get enough of them doing it the same way, having a domestic doctrine comparable and substantially the same as the Section 35 pilot project that Pierre Elliott Trudeau created, then you can effect a change in international law. And what's this all going to? Well, the doctrine of discovery is pretty hard to stomach. It's been overturned. It can't be upheld as the foundation that says, you know, these are not fully human, therefore they couldn't own land, couldn't use land, etc. Now we have the Declaration that says, well, okay, yeah, they're sort of human, but they don't have the full rights of normal humans, because the member UN states will decide. And it's all about containing the Indigenous peoples within the domestic context of the UN member state. Notwithstanding treaties, in some areas this may not be an issue where they don't have treaties, but the Indigenous nations that granted permissions to the Crown to establish and exercise some partial political sovereignty in this part of the world known as Canada now, those treaties are the foundational law under which the Constitution of Canada must comply. There is no relegating or changing that simply by stating so in the Constitution Act 1982, simply by stating so in domestic courts, simply by stating so in Bill C-15. Doesn't work that way. But, as said, if Indigenous peoples go along and feel this does speak the truth and this is the new reality, and act consistent with that, and act as if only merely domestic ethnic minorities, then that is indeed what over time you will indeed become. So countering all these decades of efforts, it's really quite simple, and I'll get to that in a minute. Again, consistency now. The Government of Canada must, in consultation and cooperation with Indigenous peoples, take all measures necessary to ensure that the laws of Canada are consistent with the Declaration. Now remember, they've already said that the Declaration has to be consistent with Section 35. So basically, you can read this as saying that all the laws will have a component that is consistent with the Section 35 domestic doctrine. There's nothing new there. But key there, right? In consultation and cooperation. There's no choice here. There's no control. This is all as the UN member state will decide. The minister must, in consultation and cooperation, and again, what the heck is cooperation? It's something less than consultation. This is a new term that the courts will decide and attach a definition to, and perhaps will use to say, well, you didn't cooperate. We tried to seek your cooperation, but you didn't cooperate. Who knows? It's not a defined term. Consultation, we know what that is, thanks to the Section 35 doctrine. So in consultation and cooperation with Indigenous peoples and with other federal ministers, prepare and implement an action plan to achieve the objectives of the declaration. And then they'll do an annual report. Within 90 days after the end of each fiscal year, the minister must, in consultation and cooperation with Indigenous peoples, remember as defined as Aboriginal peoples under the Section 35 doctrine, prepare a report for the previous fiscal year on the measures taken under Section 5 and the preparation and implementation of the action plan referred to in Section 6. So all we have basically is an action plan to be created and reviewed each year, annual sort of consultation reported on to say, well, here's what we told them we were going to do, and creating an even larger foothold for the domestic Section 35 doctrine to permeate all Canadian laws. That's really what's going down here. So you can't be silent. You got to know what you're doing and how to say it. I'm not going to share this publicly in terms of how it's addressed, but do know this. Anyone who wants help with this, I'm available. You will need to gather some information. You will need to get together all agreements that have been entered into. So if they're under child and welfare, education, health, whatever's been entered into, plus the BCRs that the band councils have passed to before signing into those. Then any other agreements, arrangements that have been participated in or agreed to. So basically a snapshot, an audit of what your band, either from previous chief and council, present chief and council, what have you signed into? What's been signed into? This is not a matter of finger pointing. This is, you really need to get together everyone in order to protect against what is coming down. You can fight later about whose fault it was. That's not the point. The exercise right now is to do your damage control, and you need to do it now. And not lobbying, as I said, not wasting your time there. This work needs to be done at home. You need to find out what you're part of, what's been signed into, and there is a way to ensure that that will not speak for your next generations. Remember, chief and council, you've been, doing the best. You have to assume doing their best. Funding needed for people's needs. Funding being constrained and cut off. These are very deliberate strategies, to get you to the table, to get you to sign. So basically, you need to view this, all of these things have been done, as attempts to mitigate your circumstances. As such, though, those agreements, those BCRs, none of that can stand alone to speak and represent you. You need to clarify exactly what's going down right now, exactly what the situation is, and consider these transitory times. These are not end times. You still have within your complete control and choice where to go from here and who you are. Are you going to remain Indigenous nationals of your nations, having important treaties in place that protect you for all time? Or are you going to accept this domestic subclass human regime that puts you and your land in Canada? That's your decision. Make a choice, or as I said in the Facebook post that I read from, will be made for you. So again, it's not a lot of work to do. Once you get, gather your documents, gather what you have, a quick review by me and a few words given to you is all that'll be needed. But ideally, this is not an exercise of grassroots band members pointing fingers at band council. This is a time to come together, do the work that needs to be done. It's not expensive. It doesn't take a lot of time. You should have everything at your fingertips in terms of informing me, for example, of what your specific situation is. Because the more specific you can be in addressing your damage control, the more effective it will be. And that's all I have to say.